I was notified the other day by Melania Trump's lawyers that they intend to sue me for $1 billion. These are called SLAPP suits. They may have really no chance at all of proving defamation, but they sue anyway.
Melania Trump may have walked herself straight into a legal nightmare of her own making, and the irony is that it all started with threats. Not court filings, not evidence, not sworn statements, just threats. For months now, Melania Trump has taken the aggressive position that any journalist or author who so much as hints at possible connections between her, Donald Trump, and Jeffrey Epstein is committing defamation. Her posture has been blunt and forceful, even suggesting such a connection she claims is legally actionable. And instead of quietly denying the allegations or letting them fade, she chose to escalate. She sent warnings. She sent deadlines. She sent legal threats demanding apologies and retractions, insisting that reporting on the topic cross a legal line. The problem is that once you start threatening journalists, you don't control how they respond. And in this case, she threatened the wrong one.
I can't live like that. And as a matter of fact, there's nothing I would like better than to get Donald Trump and Melania Trump under oath before a court reporter and ask them what are the details of their relationship with Jeffrey Epstein, what went on here.
Michael Wolff is not a random blogger. He's not a social media commentator. He's a veteran author and journalist who previously served as Donald Trump's biographer. He knows the Trump world intimately. He knows the people. He knows the social circles. And perhaps most importantly, he knows how they operate when challenged.
For those of you who don't know me, my name is Michael Wolff. I've written 4 books about Donald Trump. And before his death, I extensively interviewed Jeffrey Epstein, not least of all about his relationship with Donald Trump.
Wolff has written extensively about Trump, his family, and their private lives, and he has never shown much interest in backing down when threatened. If anything, confrontation tends to make him dig in deeper. So, when Melania Trump's legal team sent Wolff a demand warning him to apologize by a certain deadline over reporting related to her alleged connections to Epstein, connections she flatly denies, Wolff didn't retreat. He did the opposite. He went on offense. Rather than apologizing, Wolff filed a lawsuit against Melania Trump in New York State court. But this wasn't a defamation suit. This wasn't a countersuit claiming she lied about him. Instead, Wolff invoked New York's anti-SLAPP laws.
My lawyers last night, turning the tables and refusing to acquiesce to these threats, went into court in New York and asked for a declaratory judgment. Effectively, I am suing Melania.
SLAPP stands for a strategic lawsuit against public participation. These laws exist to protect journalists and speakers from being bullied into silence through legal threats. Wolff's argument was simple but powerful. Melania Trump's threats to sue him were not about protecting her reputation, but about chilling his First Amendment rights and intimidating him out of reporting on a subject of public interest. Under New York law, that kind of conduct itself can be actionable. Wolff asked the court for injunctive relief, essentially an order stopping Melania Trump from continuing to threaten him with litigation for doing his job. And here's where things get especially uncomfortable for her. By filing that lawsuit, Wolff opened the door to discovery.
It's the ability to subpoena witnesses. So everybody who has been involved in this Epstein-Trump circle is going to have to come forward and testify.
He created a legal path that could require Melania Trump to answer questions under oath. Questions not just about the threats themselves, but about what she knows, what she doesn't know, and why she reacted so aggressively in the first place. This is the moment where Melania Trump appears to have realized she may have overplayed her hand. Instead of responding to Wolff's lawsuit in state court, instead of filing a defamation case against him like she threatened, instead of meeting him head-on and proving her claims in court, she pivoted. She did not sue Wolff for defamation at all,
The discussion is what kind of relationship that they had. And a lot of these are questions. What kind of, who introduced them, in what circumstance, all of these questions, which clearly the Trumps do not want asked, and they certainly don't want answered.
That alone raises a glaring question. If she truly believed his reporting was defamatory and false, why not file the lawsuit she promised? Why issue a deadline, threaten massive damages, and then not follow through? The answer may lie in what discovery would look like. Defamation lawsuits invite scrutiny. They allow the defendant, in this case Wolff, to seek evidence, demand documents, and ask probing questions under oath. And if Melania Trump were to sue, she would likely have to answer questions about Epstein, about her social history, about Trump's past associations, and about events she would much rather keep vague. That kind of exposure carries serious risk. So instead of suing, she tried a procedural maneuver. Melania Trump filed what's known as a removal action in federal court. She took Wolff's New York State case, where Wolff is the plaintiff and she is the defendant, and attempted to move it into federal court. Her argument hinged on residency. She claimed she is not a New York resident, but a Florida resident, and therefore the case qualifies for federal jurisdiction under diversity rules. Different states, more than $75,000 at stake, federal court, but she didn't stop there. Once in federal court, her team then argued the case should be transferred out of New York entirely and moved to Florida. And not just any Florida court. The destination would place the case within the jurisdiction of a judicial environment far more favorable to Trump world interests. This two-step maneuver, removed to federal court, then transfer to Florida, would accomplish several things at once. It would delay the case. It would make it harder and more expensive for Wolff to litigate. And most importantly, it would put physical and procedural distance between Melania Trump and any immediate obligation to sit for a deposition. But Wolff and his legal team weren't buying it. They challenged her claim of Florida residency directly. Wolff asserted that Melania Trump actually lives in New York, specifically at Trump Tower. According to Wolff, when attempts were made to serve her with the lawsuit, she actively avoided service. Wolff claimed he went to Trump Tower and spoke with staff who confirmed she lived there, even if they refused to accept service on her behalf. Meanwhile, her lawyer, who had no problem threatening Wolff with a billion-dollar lawsuit, suddenly refused to accept service when Wolff attempted to formally deliver the complaint. That inconsistency matters. If Melania Trump is, in fact, a New York resident, her entire jurisdictional argument collapses, and that's why Wolff's lawyers are now pushing for jurisdictional discovery. They want evidence. They want records. They want to know where she actually lives, not where she claims to live for convenience or legal advantage. Jurisdictional discovery is narrow but powerful. It allows one side to demand documents and testimony solely to determine where a party resides. That could include travel records, flight manifests, credit card usage, mail delivery locations, housing records, staff testimony, and sworn statements. It could even include a deposition of Melania Trump herself, under oath, focused initially on nothing more than where she spends her time. And once someone is under oath, questions tend to expand. Wolff's legal team has already signaled its intent clearly. They do not accept her claim of Florida residency at face value, and they want the court's permission to prove otherwise. If Melania Trump refuses to cooperate with this discovery, Wolff argues the court should draw an adverse inference, essentially assuming she is hiding something, and send the case back to New York State Court, exactly where Wolff wants it. That's where this stops being a simple procedural dispute and starts becoming something much larger. Because if it turns out that Melania Trump has been representing herself as a Florida resident while actually living primarily in New York, that raises a separate set of legal and financial questions far beyond this case. And that possibility alone may explain why her team is fighting so hard to avoid discovery. This is no longer just about a journalist and a threat. It's about control, exposure, and the risk of having to answer uncomfortable questions under oath. Questions she may never have expected to face when she decided to threaten the press instead of ignoring them. And this is only the beginning. What makes this situation even more precarious for Melania Trump is that her attempt to delay and redirect the case may actually accelerate the very outcome she's trying to avoid. By removing the case to federal court and claiming Florida residency, she didn't just buy time, she invited scrutiny. Jurisdictional challenges are not decided on vibes or press statements. They're decided on evidence. And once residency becomes a contested issue, the court has the authority to demand proof, not promises. Wolff's legal team is now positioned to ask a federal judge for permission to conduct jurisdictional discovery before any motions to dismiss are even considered. That means before Melania Trump can argue the case should be thrown out, she may first have to prove where she actually lives. And proving that isn't as simple as filing an affidavit saying, I reside in Florida. Courts look at where someone actually spends their time, where they sleep, where their family lives, where their mail is delivered, where their financial life is centered, where their child goes to school. That last part is especially awkward. Barron Trump attended school in New York for years, and Melania has always been publicly described as deeply protective and closely involved in his daily life. During Donald Trump's presidency, Melania famously did not reside full-time in the White House. That was widely reported and never really disputed. The idea that she would suddenly be living full-time at Mar-a-Lago while her son attended school elsewhere, while Donald Trump spent extended periods in Washington and while she rarely appeared publicly in Florida, is a claim that invites skepticism. Wolff's argument is not subtle. It's essentially this: you don't get to pick your legal residence based on convenience. You don't get to say Florida because the laws are friendlier or because it helps you avoid a New York courtroom. Residency is a factual question, and facts can be tested. If the court agrees to jurisdictional discovery, Melania Trump could be required to turn over extensive records, private flight manifests showing when and where she traveled, security logs, financial transactions, credit card statements showing patterns of spending, mail forwarding records, staff schedules, housing arrangements. All of it paints a picture of daily life, and daily life is what determines residency. This isn't speculative. This is standard practice in contested jurisdiction cases, and once discovery begins, it rarely stays neatly contained. Even though the initial purpose would be to determine residency, sworn testimony creates a record, statements can be compared, inconsistencies can be highlighted, and if a witness appears evasive or misleading, that becomes its own issue. Courts do not look kindly on litigants who appear to manipulate jurisdiction through half-truths or strategic ambiguity. This is why Melania Trump's legal maneuvering looks less like confidence and more like avoidance. If she were truly comfortable defending herself in court, she could have sued Michael Wolff for defamation the moment she claimed his reporting was false. She could have forced him to prove his statements. She could have taken the offensive. Instead, she issued threats, set deadlines, and then declined to follow through when challenged. When Wolff sued her, she didn't counterclaim. She didn't welcome the opportunity to clear her name. She tried to move the fight to a different venue and slow everything down. That behavior tells a story, whether she intends it to or not. It suggests an acute awareness of what discovery could uncover, not just about Epstein, but about her own past, her movements, her associations, and her credibility. Melania Trump's background has always been surrounded by unanswered questions. Her education history has been inconsistently described. Her modeling career has gaps and ambiguities. The circumstances under which she met Donald Trump have been recounted differently over time. None of this automatically implies wrongdoing, but it does mean there are areas she has worked hard to keep private. Discovery destroys privacy, and the more aggressively someone tries to avoid it, the more determined the other side becomes to get it. Wolff understands this dynamic very well. He isn't just seeking to protect himself from legal threats. He's testing whether those threats were empty bluster or an attempt to silence reporting that makes the Trumps uncomfortable. Anti-SLAPP statutes are designed specifically for situations like this, where powerful figures use the idea of crushing lawsuits to intimidate critics. If Wolff succeeds, Melania Trump could not only lose the procedural fight, but also be ordered to pay legal fees and face a court ruling affirming his right to continue reporting. That would be a humiliating outcome for someone who attempted to shut the story down through intimidation. And the federal judge overseeing the case will have to make some immediate decisions. Does the court even have jurisdiction? Is Melania Trump truly a Florida resident? Should the case be transferred, or should it be sent back to New York State Court, where it began? Before answering any of those questions, the judge may agree that limited discovery is necessary to establish the facts. That's where the risk spikes, because once Melania Trump is under oath, even if initially only to discuss residency, she is in a legal environment where lying carries consequences. Evasive answers can be challenged. Documents can contradict testimony. And if she resists discovery, refuses to produce records, or attempts to stonewall, Wolff's lawyers have already warned they will seek adverse inferences against her. In plain terms, they'll argue that her refusal to cooperate should be interpreted as evidence she has something to hide. This also explains why her legal team matters. On one hand, she is represented publicly by a massive, high-powered firm with deep resources. On the other, the lawyer who issued the initial threats and refused service is a solo practitioner with a history of filing aggressive but flimsy litigation on behalf of Trump interests. That disconnect alone raises eyebrows. Why threaten with one lawyer and litigate with another? Why issue ultimatums through someone unwilling to accept service of process? None of it inspires confidence. Meanwhile, the longer this drags on, the worse it looks politically. Melania Trump has kept a relatively low public profile for years, carefully avoiding the nonstop scandals surrounding her husband. But this case pulls her directly into the spotlight and connects her name, once again, to Epstein, a subject the Trump world desperately wants buried. Every filing, every motion, every leak from this case keeps that association alive in the public mind, regardless of the outcome. And this is where the attempt to delay may backfire most dramatically, even if Melania Trump ultimately prevails on jurisdiction or gets the case dismissed. The process itself may force disclosures she never wanted to make. The journey, not just the destination, carries risk. The questions get asked whether she likes them or not. The media covers the dispute regardless, and the act of fighting discovery becomes part of the story. What began as an effort to silence a journalist has now turned into a procedural battle that threatens to expose far more than the original reporting ever did. And unless the court shuts it down immediately, Melania Trump may soon find herself facing the one thing she has tried hardest to avoid: sworn questioning on the record, with no press release or legal threat capable of making it go away. And that's before we even get to what happens if the case ends up exactly where Wolff wants it, back in New York State Court, moving forward with full discovery and a deposition looming. Because if that happens, the stakes increase dramatically. If this case is sent back to New York State Court, the consequences for Melania Trump could be far more serious than she likely anticipated when those initial legal threats went out. At that point, the procedural games end and the substance begins. Michael Wolff would get what he has been seeking from the start: the ability to move forward with discovery in a court that has clear jurisdiction, familiar anti-SLAPP protections, and far less patience for delay tactics. And discovery, once it begins in earnest, is not something that can be tightly choreographed or carefully stage managed. Depositions are not press conferences. They are not scripted. There is no friendly moderator. There is no ability to deflect with vague language or rhetorical flourishes. Under oath, questions must be answered directly, or a legally valid objection must be made. And even then, objections don't make questions disappear. They simply preserve issues for later. The questions still land. The record still exists. And the witness's demeanor, hesitation, confusion, defensiveness becomes part of the evidence. That is what makes this so dangerous for Melania Trump. Wolff has been very clear that his interest is not limited to the threat letters themselves. He wants to understand why she reacted the way she did, what she believes is defamatory, and what facts she claims make his reporting false. That line of inquiry inevitably leads to questions about Epstein, about social connections, about past events, and about what Melania Trump knew or did not know at various times. Even if she denies everything, Those denials would be made under oath and subject to scrutiny. And once sworn testimony exists, it doesn't live in a vacuum. Statements can be compared to prior interviews, timelines can be tested, third-party witnesses can be called, documents can be introduced, the deposition becomes a reference point for everything that follows. If something later contradicts it, that contradiction becomes a problem. If something earlier conflicts with it, that conflict becomes a problem. This is why powerful public figures are often extremely careful about initiating litigation. Lawsuits are not just weapons, they are doors. Once opened, they let other people inside. Melania Trump's attempt to avoid this outcome by rerouting the case through federal court and into Florida looks from the outside less like a confident legal strategy and more like a desperate effort to stay out of the witness chair. And courts are generally sensitive to that. Judges do not appreciate litigants who appear to be gaming jurisdiction to avoid accountability. If a judge concludes that removal was improper or strategic rather than legitimate, the backlash can be swift and unforgiving. There is also a larger risk hovering over all of this: credibility. If Melania Trump tells a federal judge she lives in Florida and Wolff's lawyers prove she actually spends most of her time in New York, that doesn't just affect jurisdiction, it affects how every future statement she makes is perceived. Credibility, once damaged, is incredibly hard to restore in legal proceedings. Judges remember, opposing counsel remembers, and transcripts don't forget. Then there's the issue no one in Trump world ever wants to talk about openly: secondary consequences. Residency is not just a procedural checkbox. It has implications for taxes, benefits, filings, and representations made in other contexts. No one is accusing Melania Trump of wrongdoing on that front in this case. But if evidence emerges that she has misrepresented her residence elsewhere, that evidence does not remain neatly contained. Legal systems have a way of sharing information, especially when inconsistencies surface under oath. And this all circles back to the original mistake: the decision to threaten rather than ignore. Had Melania Trump simply denied the reporting and moved on, this likely would have faded like so many other controversies. Instead, she escalated. She attempted to intimidate. She put deadlines on journalists. And in doing so, she triggered a legal mechanism specifically designed to protect speech from powerful figures who try to suppress it. Anti-SLAPP laws exist because courts have seen this pattern before. And when they apply, they can be brutal to the party who overreached. Michael Wolff understands the moment he is in. He understands that once someone tries to silence a journalist through threats, the journalist gains leverage, not just morally, but legally. And he is using that leverage to force transparency, or at least to force accountability. This isn't about whether Melania Trump likes what was written about her. It's about whether she can use the threat of ruinous litigation to shut down reporting she finds inconvenient. That's a question courts take seriously. Meanwhile, Melania Trump's public behavior only adds to the unease. Her recent appearances have been stiff, scripted, and detached, fueling speculation rather than calming it. If this is how she performs when reading prepared remarks, critics are already asking how she would handle hours of unscripted questioning by a seasoned attorney. Depositions are grueling even for experienced witnesses. For someone unaccustomed to sustained legal interrogation, they can be overwhelming. And the irony is hard to miss. In trying to protect herself from scrutiny, Melania Trump may have invited more of it than ever before. In trying to silence one journalist, she may have created a case that attracts national attention, court filings, sworn testimony, and months of coverage. In trying to avoid discovery, she may have made discovery inevitable. At this stage, the best outcome for her would be a swift dismissal with no discovery and minimal commentary. But every move she has made so far has pushed the case in the opposite direction, toward delay, dispute, and deeper inquiry. Courts tend to reward cooperation and punish gamesmanship. If a judge senses that this entire maneuver was designed to run out the clock or dodge accountability, the response may be sharp. The final twist is that none of this required Michael Wolff to prove anything about Epstein at all. The case doesn't hinge on whether his reporting is ultimately correct. It hinges on whether Melania Trump's threats crossed a legal line. And by fighting that issue so aggressively, she has placed herself in a position where she may have to answer far broader questions than she ever intended. That's the real risk here. Not just losing a motion, not just being sent back to state court, but being compelled to sit down, raise her right hand, and answer questions on the record, questions that no amount of legal bluster or procedural maneuvering can make disappear. And once that happens, whatever comes out won't be controlled by press releases or carefully worded statements. It will be controlled by transcripts, exhibits, and sworn testimony. That's the moment when threats stop working. And it may be the moment Melania Trump realizes that the attempt to shut this down only ensured it would never truly go away.